Hello beautiful people, how are we doing today? You are in another video of Lamboglia Law Office, and today we're gonna be talking about a very important topic: wills. Like you read on the title, we're gonna be discussing wills, and I cannot emphasize this enough. Wills are very important, especially if you're gonna be living by yourself in Panama and your heirs are in another country, right? It's always smart to plan ahead in the event of a sudden death. So what is a will? A will is a document that is going to guarantee the distribution of your assets according to your wishes. And of course, this document is going to avoid a lot of expense and a headache to your heirs, whoever they might be. Right? So let's talk about the process of inheritance in Panama. How does it work? So in Panama, we have two different type of processes. If you have a will, it is a testate process. If you don't have a will, it is an intestate process. So even if you don't have a will, your heirs, of course, can go to probate court and basically obtain their inheritance. If you left a will, right, for your heirs, then they also have to go to probate court. So in Panama, if you have a will or if you don't have a will, your heirs are gonna need to go to probate court nonetheless. So please keep this in mind. This is very important. So let's talk about what are the types of will in Panama. In Panama, we mainly manage two different types of wills: the open will and the closed will. The most popular will is gonna be the open one, because this will is safer for all the parties. And how does this will work, the open will? So I would recommend hiring an attorney to help you redact the will according to your wishes and to help you throughout the process and guarantee your safety, and that your will, of course, complies with all the law and legalities of Panama. So the first step, your attorney has to do the will, again, according to your wishes. The will is elevated in a public deed. Your attorney is going to make an appointment with a notary public, and then you physically have to be in Panama and go to the notary to do the process of the will once, of course, it is done in public deed. Your attorney is going to be there, yourself, the notary public, and some witnesses. The will is going to be read out loud in front of everyone. And if you do not understand Spanish or read Spanish properly, you're gonna need an interpreter from English to Spanish there. Of course, this to guarantee your understanding everything that's gonna happen in there, and that, of course, again, you're guaranteeing your safety in the will. Another important note: if you don't read or understand Spanish properly, the will also has to be translated from Spanish to English, so you understand it perfectly, of course, by an authorized translator here in Panama, right? So when you're in the appointment, again, the will is gonna be read out loud. You're gonna have to sign the will. The notary is gonna be signing, the witnesses. You're gonna put your fingerprint in the paper. There's gonna be photos and everything proving that you yourself went there with all your capacities and did the will that day, right? So after that, the will, one copy is gonna be kept in the notary, another copy is gonna go to your attorney, another copy to you. And I would recommend, it is always smart to let your heirs know that you did a will, to give a copy to them, also the contact of your attorney in case of a sudden death, they know who to reach, so they can, of course, process your assets as you wish. So that is the basic process on how to do a will in Panama, how it is done, and it is very important, again, to hire an attorney to help you with the steps and to make sure the will is done legally with all the ribbons, so nothing happens in probate court, right? Super important. Now, another question that I get a lot from my clients is, when do I have to get a will? Honestly, if you don't have any assets in Panama, it is not really necessary to get a will until you do have assets, maybe a car, a property, shares, etc. But I know there's some people that they think ahead and they want to make sure everything is, gonna be okay, of course. So if you don't have any assets, you are still able to do a will. You can do, let's say, a general will, that you're basically including all your present and future assets, and you're going to be mentioning the heirs and the percentages if you want, right? If you do have assets at that point, of course, you can go specific. An example, I'm going to leave my car to John, I'm going to leave my house to this daughter, etc. So you can actually specify all your assets and the beneficiaries of each asset of all the assets. So again, you can do it before you have any assets, you can wait until you have assets, so it is up to you, and you always have to make the decision that makes you feel safer and more comfortable, of course. So yeah, this is basically how wills and probate court works in Panama. I'm not gonna go into that because the topic can be very broad, but in conclusion, it is always smart to let's say save headaches to your heirs regarding time and money. And again, even if you leave a will, they would still need to go to probate court, but the process is a little bit shorter and less expensive than not leaving a will, right? So yeah, guys, this is everything for today's video. Thank you so much for watching. We appreciate your support. If you have any questions or doubts, you can leave them in the comments below. You can also send us an email to info@lamboglialaw.com. Send us a WhatsApp message. Check out our website, our Instagram, our Facebook, and of course, don't forget to like this video and subscribe to our YouTube channel for more content. Bye.